Hello again. Council tax statutory set-aside hearings appeal. In the original Act, the court would have been required to serve a summons instead of just a statutory demand being served by the council, but this no longer applies. Now you are basically following the same procedure in the court as if you are bankrupting yourself. Is this the reason 2 bankruptcy petitions are being filed by the council instead of 1? You only have a very short period of time to set aside a statutory demand. The court will treat this as private correspondence of the judge, which of course it is not. You may find that the court date for the hearing is deliberately moved forward and backwards several times to cause confusion and distress. If you are lucky enough to find a decent counsellor to witness events, you may find that the district judge may grant an order that the council produce an affidavit because they know that the council should have filed a certificate of service before the hearing, and that without it, the case should have been automatically struck out. And they also know that you hold evidence of wrongful service, which they do not want to deal with. You might also find that the councillor is summoned afterwards to a meeting by the chief executive of the council for a good telling off for daring to witness council corruption, even though the only way they could have found out is through their council staff or the court staff. But of course, this order for an affidavit to be produced will simply be ignored by the council and the court. They do this by handing over the case to a deputy district judges who will ignore all your evidence and refuse to give you permission to appeal, and will declare that you have agreed to the debt, even if you have not, and may turn it into a costs hearing instead for the council's agents. But don't forget, these costs cannot be added onto the statutory demand. The court will conveniently forget to send you the judge's reasons why you have not been given permission to appeal, or to send you out a copy of the order in time to appeal. If you do manage to appeal to the High Court, make sure you send it special delivery or at least recorded delivery. But you might find that they are also part of the game plan and will continually return your paperwork as out of time and use various other excuses, even though you have proof that you filed it in time and with the correct fee showing on their website. The reason is they want you to ask for permission to appeal out of time so they can take your money and then say no. After all, they couldn't really allow you to prove corruption in the lower courts. It would not be good for business. If you have the audacity to complain about the judge afterwards ignoring and refusing to see your evidence of the council process server failing to serve the documents correctly, you will be told the judge can choose which evidence he wishes to see, which equates to he can turn a blind eye and force through the court whatever order the council desires. In bankruptcy proceedings, this will be your home being obtained through fake evidence and deceptive means, and all sanctioned by the courts. Why are the elected councillors failing to do their job in protecting you from unscrupulous counsel and court staff who target individuals? This makes them just as bad. Thousands of pounds are being paid to specially selected outsourced agents chosen by council officers. Why is this not being put out to tender by the councils? Are the councillors simply not bothering to question anything because they are also collectively receiving thousands of pounds per week in allowances? Beware of the majority of wolves in sheep's clothing who promise to investigate but do nothing.